Hey, via telephone, Joseph Joey Torts Ferretti, mainstay on our Friday morning program. Joe will be in studio tomorrow, so we're going to make way for an extra body in there instead of on the phone. Joe, good morning, sir.
Good morning. Yes, I'm very much looking forward to that, as opposed to what I have lined up for today. Rob, I'm up in the Eastern Panhandle here handling a legal matter for a client, and of course I can't identify him, but I know he's listening, and so I'm going to say he's a very difficult and demanding client, and it's just going to be a tough day for me.
Does it coincide with anybody who may have left the show early today?
Perhaps I can't identify him, but I do know he's listening.
Yeah. Okay. Well, very good. First and foremost, the courts, especially in Washington D.C., and heck, some of these cases are being adjudicated all around the country, have been, as they say, drinking from a fire hose lately. And I want to get to some of those federal decisions, Joe, in a moment. But first, I want to start in West Virginia, where Judge Joseph Goodwin recently dismissed a case that was brought to him on behalf of children, but he had to dismiss the case before actually ruling on it. But when he did, he gave a very stern commentary to the state of West Virginia as the way it is handling its children. Can you go into that a little bit?
Sure can. Rob and Matt, this was a case that we had actually referred to previously on the Friday 5 discussions about the state of affairs of our foster care system in West Virginia and the fact that this case was pending. It was pending since 2019 in the Southern District Court in West Virginia, which is a federal court. And the case was essentially brought, and their allegations were all about the foster care system. The case was a class action on behalf of a certain number of children who were in the foster care system in West Virginia and who alleged that their constitutional rights were being violated due to the state of affairs regarding our foster care system. I think we can agree and understand that the rights they alleged were violated were their rights to the freedom from mistreatment, the right to services, to prevent unreasonable risk of harm, the right to a safe environment, the right to a limited time in custody, only designed to meet the goals of the foster care system. And that's the time is supposed to be limited. It's not unlimited in terms of when they're in state custody. And these rights flow from the fact that they are taken out of their homes by the state because it's determined that their home environment is unsafe. So what they alleged was, well, you're putting me into a foster care system that is equally or perhaps even more unsafe, and that's a violation of my rights. So Judge Goodwin eventually took this case over after a number of years, and he started analyzing this from a purely legal perspective, which is, as a judge, I'm looking at what these plaintiffs are asking me to do as a court. And the issue becomes one of, it's called redressability. The plaintiffs have to allege in their lawsuit a number of things, that there's been some cause of action that they have, some negligence on the part of some other agency or individual, and that they've been harmed as a result, and that the court is able to fashion a remedy or a solution to the problem. If a court is unable or just and its limitations don't allow it to do that, then the court is able to say that we can't offer redress to the plaintiffs. We cannot possibly fashion a remedy for them. So the plaintiffs don't have standing to bring this case because they can't convince us that we as a court can help them. And so it becomes a matter of jurisdiction. If there's no standing, then the court doesn't have jurisdiction over the case. And in this particular case, that's what the court determined. We can't help solve the problems you're bringing to us, so we're going to dismiss the lawsuit. And that's what happened. Now, as we'll get into just in a few minutes here, that is no approval, or that's not a victory for the state of West Virginia regarding its foster care system. If anything, if you read the court opinion dismissing the case, it's a rather strong indictment of the system, because the court found that the system, the problems there are so pervasive, they're so all-encompassing that it would require the court to essentially do a tear down of the agency, of DHS, Department of Health Services. It would require the court to tear that down and start over. And that a court cannot do. As the court stated, that's the matter for the legislature and elected officials to handle. They're going to have to set policy, and they're going to have to reform this agency. The court, it just cannot do that. So that's the reason why the case was dismissed. And in my opinion, it further imperils these kids, because the whole reason the case was brought in the beginning was because the legislature was either unwilling or unable to solve the problems themselves. And now we have a court system throwing up their hands saying, we can't help you. So where does that leave these kids in the foster care system?
Well, Joe, I'm struggling with, I understand why the court cites for its reasons for dismissal that it didn't have the ability to redress the issue, but that doesn't seem like a tricky factual pattern that you have to figure out. Like, that should have been figured out more than, instead of 6 years later.
Yeah, well, this was a new set of eyes looking at this case. I think there was another judge who had the case previously. I don't know if it was Chuck Chambers or whoever it was down there in the Southern District, but Judge Goodwin took over the case, and he states in his dismissal order, Matt, that he's looking at this differently, and he went and evaluated cases that have been filed across the country regarding state agencies. So some of them had to do with foster care systems. Some had to do with the agencies that try to get divorcees to pay their child support and things of that nature. And he cited to the failings of the court to be able to come up with appropriate remedies in those kinds of cases. And he essentially said, look, we have to recognize courts have limitations. And what these folks were asking for was for the court to step in and devise policies and procedures to help these kids, and to appoint a special master to make sure that those new policies and procedures were being followed. But it got so granular in this case. The plaintiffs were asking for the court to oversee agency hiring and budgeting and examination of caseworker caseloads. And, Matt, you and I have worked in the courts a long time. We know that's a lot of work for a specific court to delve into. And I think Judge Goodwin recognized that this was heavy lifting that the court was ill-suited to do.
Well, there's also some state cases that address these issues as well that are ongoing.
Oh, yeah. And look, I'm not well steeped in the law in this area, but you know as well as I do that courts have stepped in other avenues, like let's say jail conditions. There's cases across the country where courts have stepped in, they've issued injunctions, and they've said, look, you got to correct this, and the Bureau of Prisons has to start working on this, and they try to affect change. And sometimes they're very successful in doing so. But I got to believe that Judge Goodwin looked at this, and I'm trying to read between the lines here, but I think he saw a system in a complete state of failure. And he just decided that this was just too big a hill to climb for a judge sitting down there in Kanawha County to figure out what to do and how to do it, and to have the resources to do it. For example, if you're going to be looking at budgeting, what's a court to do but ask the legislature to go ahead and come up with the money? Well, we know the legislature's been kicking that around forever. And I don't know the court's going to be any more influential in getting a legislature to start cutting some checks to get the system right. And I think the judge realized that this was going to be a futile effort.
So are you familiar with the circuit court case that happened the day after in Kanawha County?
I'm not.
Judge Mary Claire Akers, they had the new director of the West Virginia Department of Human Services, and that department would be that the new secretary for that is Alex Mayer, and that department will be put under an improvement period for a year. And she appointed the monitor Cindy Largent Hill as the who's the current state Supreme Court's Children's Services Division Director, and lives in Morgan County, by the way. But So there is a state action that is, and that's relating. That was involving an incident where a juvenile who was at a hotel that the state was they didn't have anywhere else to place the juvenile, and attempted self-harm, and the guardian ad litem wasn't notified. There was like a series of unfortunate incidents and that put this child at further risk. And so some actions have been taken.
Who's responsible for the supervision for that year, Matt? Do you know?
It said Cindy Largent Hill.
That specifically will be the person who will be supervising.
Yeah, let me pull up this.
Okay.
Yeah, and
who's a fantastic person, by the way.
And that's just taking one component of this entire foster care system. And I'll tell you, the takeaway here for West Virginia residents is that some of the evidence and some of the information that was developed in this federal case is horrific. I mean, these kids are being placed in hotels, motels. Some are going to psychiatric homes and hospitals, some out of state. There was evidence that some of these kids are being drugged to sedate them for behavioral reasons, and they're also being subjected to physical and sexual abuse. These are kids being pulled out of a home because they need help, and I suspect in some cases the situation is being made worse.
That's just a horrific experience, Joe, the whole thing from A to Z. And in reading some of these comments from the Metro News article that discussed this judge's decision, A Better Childhood executive director Marshall Lowry said, "We know that the judiciary is the third branch of government that is supposed to act when constitutional acts are violated and when the legislature, for example, doesn't act. The legislature has known for 20 years that there are very serious problems in the foster care system in West Virginia." And another comment on that is the national organization that was at the heart of the case says if the executive and legislative branches were holding up their obligation to vulnerable children, then a lawsuit wouldn't have been necessary in the first place. And just to relate some of the comments, when we asked Senator Barrett yesterday, Delegate Clark today, their thoughts on this, both mirrored, Clark's mirrored Jason's, which was, listen, every time that organization comes in front of us, the health, the foster care, those who oversee that in West Virginia, Health and Human Services, we give them what they want. The issue isn't the legislature not funding it, it's the organizations that are administering it. But when we talk to the organizations that are administering it, Joe, they say, listen, we've got 3 times the caseload for every caseworker in West Virginia, and we can't keep the caseworkers because we can't pay them enough based on what the state allocates as pay for them. So it seems like neither wing here, and with the judiciary basically passing on this, it seems like nobody is actually doing anything that will solve the problem. They're all just looking at each other and pointing a finger.
Yes. And the statements from some of the plaintiffs' attorneys in this case, I certainly respect what they're saying, and there's certainly at least a kernel of truth, if not an actual truth here, as to what they're claiming. There's a great disappointment with the court bowing out of this case because they're correct. When the legislature is failing and these kids are suffering constitutional deprivations, the courts are the only way they can seek redress and perhaps change. So you could be critical of Judge Goodwin too, taking the technical way out of this and saying the court was not suitable for fashioning a remedy for these kids. But if not the courts, who? Well, I think that's a fair question.
That is a fair question. I wonder if there was some that was providing some sort of cover for legislators, or not necessarily legislators, but government officials that well, this is in court, this will be figured out, this will give us direction. Now it's just they're exposed. He's I think clear from his language, he's saying you can't hide from this any longer.
That's exactly right. Yeah, that was a quote. The legislature can no longer hide behind this case. And if they don't enact the reforms that are necessary, the judge said, throw them out of office.
Right, but in the interviews we've done with elected officials since those comments, some never heard the comments or weren't aware of them, and others aren't moved by them enough to put any fault on themselves.
Well, it as with a lot of things in West Virginia, where you can argue we're deficient, okay, from teacher pay all the way down. We know what the list is. It's a money issue. And the legislature speaks of its values through its allotments of money and how it budgets on an annual basis for the state of West Virginia. And this has to be given priority. These kids have constitutional rights, especially when they are under state custody. There's a duty there that the state has to adhere to, and the evidence is clear. It's not being done.
Let's go to some of these federal cases, Joe, and talk specifically about civil service employees at the federal level. Obviously, there's a house cleaning that's been going on there. We're hearing now there may be 70,000 employees at the Veterans Affairs Department may be terminated in the very near future. Some of these have been adjudicated in the courts, at least at the lower levels, Joe, and the decisions seem to be favoring the civil service employees. What do you know about these decisions and the backing for them?
Well, Rob, I could just tell you we're just getting started.
Amen.
I can't imagine being a federal employment lawyer in D.C. right now. Your phone has to be ringing off the hook. In the latest case, and the one that really grabbed the headlines here just a couple of days ago, was these USDA workers, U.S. Department of Agriculture. 6,000 employees were terminated. Now, these were probationary employees who had a year or less of service. But there's an agency within the agency in the civil service system for these federal employees, and it's called the Merit Systems Protection Board. Now, what this board does is it serves as an avenue for appeal with these federal employees. If you get fired or terminated from your job and you believe it was not for just cause, then you have the opportunity to appeal that firing before this board. These USDA workers, the 6,000 probationary workers, filed claims with this Merit Systems Protection Board, and the board determined, in an opinion just released a couple days ago, that they are to be reinstated for at least 45 days so further investigation can be done behind their firing. And this is just the tip of the iceberg, because if that happens at the VA and if it happens with these USAID workers, these folks are, I'm sure, ginning up lawsuits and filing appeals of their termination also. And the question is going to boil down to, does the Trump administration have the right to come in and just terminate these folks because, as they claim, their continued employment is not in the country's interest? The argument for these civil service employees are going to be, wait a minute, that's not the standard by which you can fire me. You can fire me if I am guilty of misconduct or poor performance. You can't fire me because it's some amorphous reason that's not in the country's interest to continue to employ me. And so and especially when Congress has appropriated the money and has developed these agencies to have these people on the payroll, can the executive branch come in and just start lopping off people? And that's going to be what's going to be litigated in the courts.
Mr. Harvey, you're an attorney. Any thoughts here?
It's a mess.
I know it's not your expertise.
No, it's not my expertise. And it's I'll tell you what I was thinking. It was, you cannot fire people for political reasons. And I guess that's some of what they're arguing, that this wasn't necessarily a performance decision, but a political decision, because it campaigned on, I'm going to reduce the size of government.
Well, it's been done before. President Clinton in the 90s set out to reduce the federal workforce by 400,000 people, and he accomplished that. But when Clinton did it in the 90s, it was after there was bipartisan legislation passed by Congress saying, okay, we're going to have a reduction in force in terms of federal employees. And then Clinton had his agency heads go forward and say, okay, here's where we can reduce some employees in our specific agencies. And then that matter all went back to Congress and was reviewed before the termination notices went out. It was a couple months of process and procedure in order to determine who could be let go without affecting the core missions of these agencies. And so there was some process and orderly way of doing it. Here, with the Trump administration just coming in saying, okay, I've contracted this out to Elon Musk, and here's where we're going to cut, without Congress input at all, it's probably one of the reasons why these employees are going to have a decent chance of prevailing in the appeals of their terminations.
Well, I would say
30 seconds, Matt.
Yes, maybe some of this, the chaos and the uncertainty will probably create a lot of resignations, and people just will move on.
Oh yeah, statistics show that a lot of these federal employees who do lose their jobs, they move on with their lives. The appeal process is very arduous. There's a lot of delay, and some of these folks just they get other jobs, or they decide, I've had enough, and I'm in my 60s, I quit. So many of them will leave federal employment.
Joe, thank you very much. We will see you in studio tomorrow for the Friday Five.
Okay, look forward to it.
Good stuff as always. And Mr. Harvey, thank you kindly, and stay around. We're back for a final minute here.